So following the recusal by Judge Piet Koen from the arms deal corruption trial in January, Judge Nkosinathi Chili will now preside over the matter from tomorrow. Koen said at the time that presiding over the case could infringe on former President Jacob Zuma's rights to a fair trial. So since Zuma's first court appearance in 2018, this trial has not been able to begin in earnest because of several applications. The former president is facing charges of money laundering, fraud, corruption and racketeering. Newzroom Afrika's Ziyanda Ngcobo is live for us in Pietermaritzburg tonight ahead of the appearance tomorrow, Ziyanda, and most people will be wondering if we're expecting another postponement, another delay.
Well, that's exactly what we're expecting, not unless, Tembekele, a new application is brought by former President Jacob Zuma's lawyers. And let's bring in Mpumelelo Zikalala to talk more about this, because there's a new judge now. So the issue of fair trial rights and, possible prejudice on the part of the presiding officer has been resolved. However, the former president's lawyers still take aim with the fact that Billy Downer is overseeing this matter. What else can be done to remove him?
A new application can then be brought where there are new circumstances or new facts which are going to be brought on board. Remember, when that initial application was done, Advocate Billy Downer was not charged, so was not an accused anyway. But in this case, he is now an accused in a specific case in the same court, in the proceedings which are taking place that have not been finalized as yet. So they may bring in a new application and then say, Judge, do you really want a prosecutor who is currently undergoing their own prosecution to be part and parcel of these proceedings, taking into account the rights of our client, which is the former President, Section 35 of the Constitution, to a fair trial? If you don't want that, I think it would be prudent of you to then remove that particular prosecutor, order that. But I think the state will then say, we are still steadfast in our initial standpoint. We are ready to proceed with this matter, and there's nothing which is preventing us from continuing this prosecution. Another application that can come in, if there's certain evidence or certain information which is still outstanding, in which they would say, we are not able to proceed to a trial date without this crucial information being provided to us. We have asked the prosecution or the NPA and they have not responded, so up until to date, that's where we are going to stand. We can't proceed with them. So it's those type of applications that can then come through, but that will be resolved tomorrow.
So if these applications are brought, can they be heard immediately, or would we need to have another another time set aside for these applications to be heard and then also again decided upon?
It will depend on the notice which was given to the other party, the party which is supposed to respond. So if this is something that has been discussed a long time ago, to say that on this day we are going to go to court and make this application, so please come prepared. A special provision can be made stating that maybe let's come back tomorrow or later on this afternoon to deal with these matters. This is a matter that has been long outstanding. We want to get it over and done with as soon as possible. So if we all work together and try and resolve this matter as soon as possible, then everything is going to be okay. But in this instance, I do not see, if a new or fresh application or surprise application is made tomorrow, obviously the other side would say we still need to brief our own legal reps. I want to make sure that we're prepared adequately for it. So we can't continue on the surprise basis. Give us some time to prepare.
Any other possible postponements on the basis of having a new presiding officer, or this break that we've seen between January and now it's April would have been sufficient time enough for Judge Chili to have, really appraised himself?
I think by now all the issues that needed to be dealt with, they've been dealt with. There's nothing at this moment which is in the table of the presiding officer. Remember that the first witness has not gone into the witness box, so there's no evidence which is there to evaluate. It was still pre-litigation issues or pre-trial issues that needed to be dealt with. So there's nothing which would prevent Judge Chili to say, I've heard what you needed to say. There's no application in which I'm going to entertain. Just give me dates in which the first witness is going to go into the witness box, and then let me proceed with this matter. So there's nothing which needs to be appraised of. He will simply go there with fresh eyes and simply say, I'm here now. All that I want to hear is that the both parties are ready to continue with this litigation, and when would the first witness go into the witness box?
Let's talk about those witnesses, because we know that some have died. Some may argue, an argument can be made about the veracity of what they say because of memory. This has been something that's almost 2 decades in the making. We know that one of of those witnesses would be the current minister, Patricia de Lille of Tourism, of course. And so when we do get to that stage, hopefully, is there an argument to be made as well against the type of witnesses that are brought?
Definitely. I think there's going to be a lot of fights in terms of evidence which is supposed to be admitted by the court and whether a sufficient weight should be placed on it. Now, the quality and the quantity of evidence is going to be impacted on people die, as I've stated. Some of the records may have been destroyed, and the weight in this case is on the state. They have to prove beyond reasonable doubt that the former president is indeed guilty. Now, if we don't have sufficient evidence to prove that, then we're going to have problems. The same on the side of the former president. If he cannot produce evidence which is able to exonerate him, he's going to have a problem trying to prove that he's innocent in all the instances of allegations which are thrown at him. So it's absolutely crucial that they get this matter going as soon as possible so that they're able to deal with the matters quickly. But that does not say that you must then trump all the rights and the other obligations which would accrue to the former president as per Section 35 or any other procedures which have been inserted in our law to make sure that this is just and fair trial which needs to take place in order for the accused to be found guilty or innocent.
Which then brings us back to the issue of Advocate Billy Downer, because he's the one who successfully prosecuted against Schabir Shaik, and the charges against the former president in essence emanate and are parallel to the ones that Schabir Shaik faced. So his presence in this matter would mean institutional memory. However, when it comes to witnesses, I mean, what's the weighting of having someone like Billy Downer presiding over this matter on behalf of the state?
It does matter in terms of the strategy in which the state is supposed to use, but when it comes to the witnesses, you don't know what the witness is going to state under pressure, being looked at or being watched by millions of South Africans, and certainly the pressure of being able to remember the exact sequence of events that have taken place, and certainly that cross-examination which is meant to gruel you and extract the truth of what you are saying. So he may be there and provide maybe a strategy which is in favor of the state, but it does not mean that if it's not there, the matter cannot continue. There are a number of other legal representatives that are there, and probably they have looked and studied the matter, and they wouldn't have made the decision of charging the former president if they didn't know that the evidence that they have is going to bring them back a conviction.
Bumelelo Zikalala is a lawyer, Thembekile, and he'll be with us as well tomorrow morning as we monitor those proceedings in the arms deal matter. I mean, it's been some time since we've been coming to this court, getting postponements. In fact, in 2018, we started off at the Durban High Court. It was moved to Pietermaritzburg, and yet another postponement on the horizon. However, we don't know whether or not the former president's legal team will be bringing a fresh application to have Billy Downer removed from the matter.
Ziyanda, thank you very much for that. Outside the High Court in Pietermaritzburg, and Ziyanda will have full coverage tomorrow of the arms deal corruption trial of former President Jacob Zuma from the morning.